Hey everyone, thanks for rolling in. We'll just wait a little bit for some more people to arrive before getting started.
Very prompt people in already. It's exciting. We were thinking about doing some background music, and then we had a look for songs about bankruptcy, and it was a rather depressing selection, so we decided not to go with that.
What do you reckon?
Get started.
Alrighty, we're going to get started. People can roll in as we're going. So, hi everyone. Welcome to Justice Connect's launch event for our recently published research report, Navigating Financial Legal Problems, Understanding Help-Seeking Behaviour to Enhance Early Intervention. So Hill and I are really excited to have you all here today. Thank you for joining us. We're going to be introducing you to our research, and specifically we'll be sharing with you some of what we've learned about how people behave in the early stages of a financial legal problem, and talking about what this means for service providers in thinking about how we deliver services, particularly those targeted to the early part of a financial legal problem. But before I get started, I'd just like to acknowledge the traditional owners of the lands that we're joining from today. For Sahil and I, that's the Wurundjeri people of the Kulin Nation. And I understand that we're joined today from people all across this country and from the lands of many peoples and nations. So we'd like to pay our respects to elders past and present, both in the lands that we're working on today, but also of the lands that you're all joining us from in this session today. We'd also like to extend that respect to any First Nations people who are here with us today or watching this recording online later on. Sovereignty was never ceded, and this always was and always will be Aboriginal land.
So some quick introductions to start us off. My name is Sahil. I'm one of the researchers and report authors, and I'm joined by Mel, who you've already heard from, who's our other researcher and report author. This is also a great opportunity for us to extend appreciation and thanks to the Victoria Law Foundation, without whom we wouldn't be in a position to be speaking to you today. So the VLF funded this work through a knowledge grant, and we're grateful for both their support of the project and their ongoing interest in this research. And just a little bit more housekeeping before we get going. So we've completed this research to not only benefit our own practice here at Justice Connect, but we hope to be able to share learnings from across the sector. And as such, today's session will be recorded and will be uploaded to the Justice Connect website. We've set today's session up as a webinar, so if you won't be identified as an attendee. The only exception to that is if you ask us a question, we'll be able to see your name. You'll be able to ask questions throughout today's presentation, and we've got some time to answer them at the end. If we can't get to your question, we will send you an email with the answer in the next few days. There's also going to be a few opportunities to participate throughout. We've got a few polls, and we really want to hear from you about some of what we're talking about today. And we'll put them up at various points throughout the session. So we'll maybe just kick off with one now as a bit of a practice run. Mel will pop that up on your screen, and you'll just be able to answer where you're from. So whether you're an individual in the community or they're working in the sector, volunteer or staff member, or if you're just someone else out in the world who's interested in early intervention into financial legal problems. So you should be able to make your choice and then hit submit. And then have a look at those and then get started.
Amazing. Thank you, everyone. I can see those ones rolling in. So while you're doing that, I might start talking about today's presentation. So let's change screen. All right. A theme that's going to emerge from today's session is how we need to be putting people at the centre of the way we think about, design and deliver services, and particularly how in the context of early intervention, doing so provides us with an avenue to deliver stronger client outcomes, resolve legal problems, and build community resilience to financial legal problems within the limited resourcing environment in which we all operate. So reviewing your poll responses, I can see we're joined by a lot of people who in some way or another work with people across our country who experience financial legal problems. I'm going to end the poll and pop those results up for everyone else. So before we move on, I'm just going to apply this idea of centering individuals that we help through our services to the concept of bankruptcy itself and establish a little bit of a shared understanding and definition before we move on. So for service providers and anyone touched by these legal problems, we've got an idea of bankruptcy that might be a bit different to the way it's talked about in spaces outside of, the sector and other groups. And I think that's particularly true for bankruptcy to the public at large, which is often talked about through its relationship to business and entrepreneurship, whether that's by government, business owners, lobbyists in legislation, in news or in other media. Many of you will be familiar with the argument that bankruptcy is really great for our economy. It's the rebuttal that we come up against when we're advocating for stronger protections, changed laws, greater checks and balances on creditors. But we know as service providers who centre our communities that this idea of bankruptcy doesn't really match with the experiences of our clients. For our communities, bankruptcy is a punitive tool. It's socially patterned. It's thrust on people involuntarily. It's strongly linked with the experience of poverty, and it's something that can generate real lifelong consequences of harm, whether that harm is physical, mental, to individuals, their families, their broader communities. And from kinds of harm which someone might not ever really recover from materially, but also, as our participants told us throughout speaking to them over this last little while, something that they may never recover from in terms of their well-being. And it's addressing that impact that matters. So that's what we're going to hear to talk about today. So as we put forward in our research, any person, provided they experience a certain combination of financial strain, life events, non-financial vulnerabilities, illegal or improper conduct, and importantly, a lack of access to services that can help them at the time when it's most transformative, anyone can go bankrupt. For us, therefore, a person's journey to bankruptcy, it begins when they acquire a debt. And what this means is that every moment afterwards, it's an opportunity for services, so for free services to intervene. And it's within this context, therefore, that we argue that it's strategic for us to be adapting our service provision from what's currently dominant, which is a crisis point intervention model, to a system that helps people early before their legal problems escalate to court, let alone to bankruptcy. So, the question of how we do this in a limited resourcing environment is, I imagine it's going to be the first one on everyone's lips today. So, you'll be pleased to hear we've done this first step of identifying early intervention opportunities for you through this research. And generally what we've uncovered is that early intervention doesn't require us to reinvent the wheel or design completely new services or ways of operating. Debtors are interacting with our services already early in their journey in a myriad of different ways, and whether we know it or not, as they navigate those early stages. And so the problem at the moment lies whether that early interaction leads to the provision of a service that's capable of resolving a problem early. So we're going to talk about more of this later, but we're also going to kind of describe how, by supporting legal system navigators and their existing behaviours, we can offer early intervention now within our current models. And all of this takes us back to point one, understanding the people in our communities that we hope to serve. So by familiarising ourselves with the ways in which navigators interact with our services early, the capabilities possessed by these navigators, we can employ our limited resources in ways in which our communities, as we've found, are demanding us to. And we can be really dynamic to the diversity of need, experience and capability across and within the communities that we serve. So this image on screen now is a pretty stark representative of what I've just been talking about. So 83% of business, and importantly for us in this room, 94% of personal insolvencies relate to underlying debts of less than $50,000. So in terms of the need in our communities, we're talking about small underlying debts. We're not talking about these big investments or foreseeable outcomes of risky business ventures. These are debts incurred as part of living a life. They're car loans, credit cards, small business, startup loans, body corporate fees, council rates, buy now, pay later debt, and tax debts. So this is, some of the kinds of money lending we might expect to see across the stratum of our country, accessible and necessary for most people, regardless of their economic position, to take out or to incur over the usual course of living their lives. They're also the types of debt people incur in periods of financial hardship. And this might be why we're once again seeing personal insolvencies on the rise, in spite of all those hard fought for and won protections that were introduced during the COVID-19 period. So in 2023, over 3,000 people in Victoria entered a new personal insolvency arrangement, and they joined over 50,000 people across Australia who are currently navigating an arrangement that's yet to be discharged. And the rate in which people are experiencing personal insolvencies is rising. So in 2024, monthly personal insolvencies have exceeded 200 every month, and it's the first time that's happened since July of 2020. Importantly, also, personal insolvency figures don't tell us the full story. So as economic and regulatory conditions shift, so does the behaviour of creditors. So enforcement of lower court judgment debts is starting to emerge as a really central tool of creditor aggression. And this is something that it's not bankruptcy, but it generates really similar impacts in material terms for debtors. So it garnishes wages, it forces the sale of family homes, and it really drives social isolation. And these lower court enforcement tools, they're also accelerated processes of debt enforcement that offer kind of fewer opportunities for intervention by services such as, the people in this room today. So as enforcement trends earlier, crisis-driven service provision, which considers that court essential moment right before bankruptcy as a key intervention opportunity, they may no longer be servicing a significant cohort of Victorians with really significant financial problems. So this is to say that across the board, services as they currently are, they've not been able to reach debtors in time enough. People with debt are entering bankruptcy for debt significantly smaller than what might otherwise warrant a declaration of personal insolvency, and that's merely because of a lack of timely advice. So where debtors are assisted by service providers at those final stages, whether that's in federal bankruptcy lists or in lower courts, there is often very little that can be done. So how do we do the research? Most of what we knew when commencing this research, it related to either the creditor, the courts, how a person uses the courts to appeal decisions, what trustees do and how people interact with trustees, and what impacts bankruptcy has on a person after it comes into effect. We knew significantly less about all the different things that happen in between these external milestones, and certainly we knew very little about what a person's internal state was when a legal problem emerges. So for us, if the problem lies in understanding how services can better respond to the needs of people beginning a journey to bankruptcy rather than ending it, and understanding what people think, do, know, assume, feel, that stuff all became essential. So over a year, we spoke to over 60 people directly impacted by personal insolvency, a mix of staff at generalist and specialist service providers, and people with lived experience of financial legal problems that ended badly. And those people were both former clients of Justice Connect, of other services, and there were also people that weren't able to access help at any point in their journey at all. So we did this with mixed methods. We did a mix of surveys, interviews, pilot service provision, evaluation, and we got a mix of quantitative and qualitative data. And this complexion was particularly crucial to putting together both insights into some of those clear trends regarding knowledge held and action taken of participants at different stages in their journey, while also adding that extra kind of qualitative depth. So learning those important details on things like emotional state and belief and assumptions and personality and resilience and motivation and all those different things that impact a person's decision-making, and also their legal capabilities as they navigate our ecosystem of free legal help. So what did this look like in practice? We adopted a strength-based approach in designing our research and our methodology, but also in completing our analysis and developing insights and recommendations. A strength-based approach is one that kind of utilises co-design methods, and it really focuses on the resources, the skills and the strengths that people currently have. So leveraging capabilities people already have in their back pocket and leveraging their agency in order to develop future solutions that we can implement. So for financial legal problems, this requires figuring out what debtors currently do when they're faced with unmanageable debts, what resources they already have, what pathways they prefer or are inclined to use when searching for help. And by understanding these factors, we can then reframe the problem we're addressing, and we can design solutions and services that meet help seekers at the point in their journey that already exists, as opposed to relying on kind of making something new or establishing new behavioural detours for the people that we're trying to help. So the question is, what aspects of service design and delivery don't currently meet the express and latent financial legal need in the Victorian community?
Thanks, Mel. So in trying to reframe the problem of access to early intervention, it became clear that we needed to challenge some of the assumptions that were held, both by ourselves and by other service providers, to see if they held true or if they needed adjusting. And I think assumptions can also be thought of as generalizations or rules of thumb, really useful when dealing with large groups of people, like debtors with legal issues. But I think what we found was that by grouping people at a large scale, we weren't able to see the strengths of the individuals involved and how they might use those with the support services to achieve positive outcome in their problems. So the first step to identifying, the first step in this process of reframing the problem was to understand what services we're currently doing. As part of our semi-structured interviews, with service providers, we asked questions about the trends in services that people were seeing, the stages of matters that they typically saw when it comes to financial legal matters, if they had done any work to specifically try and target early intervention work, and what they perceived the barriers to early intervention to be. And we heard a range of responses, particularly to that last question, and these were some of the key findings. Firstly, we heard that debtors often didn't know that they had a legal problem. This was often because the problem involved money and people thought about it in purely financial terms. There was a lot of thinking along the lines of, I need to find a way to pay this money back. There was a lack of understanding from people around their legal rights, or that their lenders might be doing something wrong, which they could challenge. And it was really this lack of knowledge that led to inaction, sometimes reported as a sense of hopelessness, that there was anything they could do to improve their situation. Next, we heard that debtors avoided their issues in the early stages, commonly referred to as the ostrich effect. People buried their heads in the sand to avoid danger, really. Service providers reported that people didn't engage with the early signs of their problems, so letters of demand, or calls from their creditors. They did note that this was often because of the stress of the situation and a lack of resources to resolve the problem at the time. But regardless of the reasoning, the effect was the same. As the lack of knowledge and inaction until the problem escalated to the point where serious adverse outcomes were likely, like the loss of a home or other asset, for example. And then lastly, services reported that debtors didn't know where to look for help. So most of our service provider participants were from community legal centres, both generalists and specialists, and the feeling was that public awareness of community legal services was lacking. Additionally, debtors really seemed to struggle to navigate the information online about debt and financial issues, often leading to contact with private practitioners, both legal and financial, as well as those others operating in that financial problem space, so debt management companies, payday loan providers. So these observations from services mostly pointed to the fact that there was some deficit in client capabilities that prevented clients from resolving their problem early on. But most providers agreed that with the right help, they could be resolved earlier. So it was evident that there were many ideas about why clients weren't engaging with services in the early stages of their matter. So next we set out to hear from help seekers themselves about their perspectives on that. And our findings from people who had experienced these issues challenged a lot of the findings that we had from our service provider conversations. So most importantly, help seekers said they did look for help right away, rather than ignoring the problem. 96% said that they sought help and they knew that they were unable to pay the debt. Almost all of our participants looked for help online at some point, and half of our participants contacted a lawyer when their problem started. However, people told us that they were often turned away from help in the early stages of the problem. So for people who looked for private services or services that charged a fee, they often quickly realised that they weren't able to afford them and weren't able to pursue that. And for free services, there were often issues with eligibility, people being not eligible for a range of reasons, including the fact that their matter maybe didn't have a clear legal action by the other party, some aspects of their matter not being within the expertise of the service, so intersections with family law, commercial law, or property law were all commonly cited. or having an issue with means. So maybe they had a high amount of equity in an asset despite not having any liquid funds, and that prevented them from accessing a service. So debtors also reported that they were more likely to look for help from a professional early on in their matter. And as their matter progressed, they were less likely to look for help. But only 46% of our participants said that they looked for help in the final stages of their matter. And this diminishing motivation is really interesting because it kind of juxtaposes the fact that people are looking for help early on and not accessing it, and then they don't look for help in the final stages when they need it the most. And the divergence in findings between the service provider conversations that we had and the help seekers led us to thinking about what capabilities are required to navigate the free legal service ecosystem as it currently exists. And from this, the idea of the model debtor was formed. So when studying the journey to reach a successful outcome after receiving a service, we found that there were a set of required characteristics and capabilities to achieve this with very little friction. And as such, the model debtor idea came about, a hypothetical help seeker who fits neatly into the boxes, and effortlessly jumps through hoops. So they have the capability to make the most of the services available to them. When looked at together, it's hard to believe that this person really exists. They, particularly in the context that we're considering, they're seemingly immune to the stresses of their situation, they're meticulously organized, and they're legally astute. The model debtor is an archetype. So an archetype being an amalgamation of a set of behaviors that we saw repeated across the journey that we had mapped. And for the model debtor, we took those behaviors really from what services appeared to be requiring of people to access them. And for our other archetypes, which we'll explore a little bit later, we took that from our participant stories and the survey results that we had. So I just wanted to go through some of these capabilities and talk about how they enable people to access services well. So, for example, when we're considering legal knowledge, the model debtor knows from the start of their issue that their inability to pay their debts has a legal component. They signed a contract, they know that there's potential consequences to non-payment, and they know that they have some rights associated with that debt. They're also able to apply that knowledge well to services eligibility criteria. So they know, for example, if they have a certain type of debt, they might be eligible for a particular kind of service. And they also have a high amount of digital capability. So they're able to use sophisticated search terms to find relevant services quickly. They can discern things like sponsored posts from organic posts. And they're able to use online tools and forms to apply for services quickly. They're very proactive. They start looking for help right away. And they're often resilient to setbacks as well. So if they find out that they're not eligible for a service, they're able to keep going until they get the help they need. Lastly, their legal skills, their legal skills were also strong. So if they received advice, they were able to act on it. They were able to advocate for themselves and take steps in the process without support. And then finally, they saw the value in reciprocity. So they use their experience to help others in their networks who experience similar problems. So we've said that the model debtor is hypothetical because we didn't find any evidence to suggest that this person exists. What we did find was that there is a clear pattern in the mix of capabilities that different types of clients had, and particularly our participants, that deviated from those of the model debtor at various points in the journey. And it was those points of deviation that helped us form our other archetypes, who I think are much more likely to be familiar to those of you working in the sector. And I'll introduce you now to some of them, and I'll focus on two things when I talk about each of them. So the participant story that really helped us to shape that, and some of the capabilities that they possess. Just to note, say that the participant story that I'm sharing for each of them, it is de-identified, and also that it's not the only one that informed that archetype. We used a range of sources for that, but it helps us to understand the specific context. Thanks, Mel. So let's start with Mariam, who's our surprise respondent. Miriam had a debt issue in the context of financial abuse in the spousal relationship. Her husband had taken out credit cards in her name for a business purpose, and when he was unable to make repayments, he left Miriam to deal with the debt. Now, Miriam was a stay-at-home mum. She had no experience managing this kind of problem, and she felt completely overwhelmed and unsure how to proceed. She knew she needed a lawyer when she received court documents, but she assumed that she couldn't afford one. She did decide to go to court as a self-represented litigant and asked to be made bankrupt after this advice from family. She was completely unaware of how that might impact her family home, which she co-owned with her husband. Upon attending court, she was referred by the registrar to a duty lawyer and a financial counsellor, who both advised her on some ways to go about her proceedings. And based on this advice, she was able to negotiate a payment plan based on the orders of the court. So while still paying considerable costs, this avoided any impact to her family home. For Miriam, it was really the confluence of legal knowledge, digital capability, and emotional overwhelm that were at the heart of her being unable to access a service early on. She knew that she had a legal issue, but she wasn't aware of the free services that were available, and she lacked the digital skills to find them. She also felt isolated and ashamed of getting herself into the situation, which meant that she was unable to really utilize her personal networks to try and find appropriate help. Her ability to act on the advice at court, though, that was provided through the services she did interact with, really carefully following instructions, showed that Miriam did have some legal skills that she maybe didn't identify in herself. And I think that really points to the fact that early intervention might have helped her to find a resolution to her issue had she been able to access the service. After dealing with the issue, Miriam now helps people within her community, friends and relatives with similar issues, trying to look for help online and providing others with information. So next up is James, our repeat player. James had accrued substantial debts in the context of what he called an ugly business dispute. He had extensive experience with legal issues and legal services through his business activities. However, this particular issue occurred at the height of the COVID-19 pandemic. James had suffered the bereavement of his partner, and the pandemic had left his business decimated. He had no funds to pay for representation. He looked for low-cost services or free services, but he found that he was ineligible for a combination of means and the legal matter being commercial in nature, despite the fact that the bankruptcy proceedings were personal. James had considered selling his family home to service the debt, but he also felt like there were grounds to fight the matter legally, and he had some knowledge to be able to do this. So while self-representing on two matters in different jurisdictions, he was referred to our Federal Self-Representation Service. He received advice on a procedural matter, which allowed him to file for an adjournment and eventually have the matter dismissed. So James and the repeat player key capabilities really are around legal knowledge, proactivity and responsiveness, which we've touched on. He made really good use of the services that he was eligible for once he found them. He did struggle with things like court processes and filling in forms. He had a condition which made it difficult for him to write coherently, which perhaps wasn't taken into account when he applied for help. And in general, what we noted about the repeat player is because they appear to be legally capable and often less distressed about their situation, they appear less vulnerable. However, I think it's important to note that James's circumstances and what he stood to lose was substantial and could have seriously derailed his life. So on to Alexia, who exemplifies our dogged debtor. At the time of her debt problem, she was the franchisee of a retail chain. She'd taken out a loan via a mortgage broker who was recommended to her by a friend. The loan turned out to be predatory in nature, and she was unable to service it, which led to swift legal action. Now, Alexia was proactive and persistent with her search for help, contacting many organisations, often being rebuffed, but she did eventually get some help from some discreet help from a drop-in service and from a self-representation service. However, it wasn't enough to prevent a poor outcome. She, unfortunately, the sheriff executed a warrant and she lost her home. So I think some of the key points in Alexia's journey were that she lacked the knowledge and skills around what the orders meant and how to challenge them. And because the advice was unbundled, she was required to take many actions and steps on her own, which perhaps was a little bit beyond what her legal capability was. The circumstances around how she entered the loan agreement also point to the fact that she maybe didn't have the legal knowledge to think about what the potential consequences of that lending were, and that maybe timely advice at that point would have prevented the issue as well. However, her strengths really were digital skills. She found many services and applied for them numerous times. She was resilient. She was able to being told services couldn't help, and she was responsive in providing further information on the matter, although she did note that it was challenging to repeat her story. And then lastly, we have Bilan, who represents our accidental client. A recent migrant to Australia, Bilan also fell prey to predatory lending, being unfamiliar with the law, the financial system, and community legal services. He did not look for help with his problem early on. The private creditor with whom he took out the loan quickly took legal action when he was unable to make repayments and sought possession of his home. Now, despite not knowing about legal services, Bilan was familiar with the Salvation Army, who acted in his local area. They, in turn, he spoke to them about his problem. They, in turn, referred him to Unison Housing because they identified there was a housing element to his issue. Unison then referred him into CoHealth because they realised that he was in fairly substantial mental distress. And then CoHealth eventually referred him to Justice Connect, seeing that the legal problem was really the root of his problem. Now, this chain of referrals, although not usually this long, is common for the accidental client. People who don't realise that there's specific help for the legal problem that they're facing, but have something else going on in their lives that they're looking for help with, which leads them to the right help because of the problem spotting skills of professionals in the organisation they're looking for help with. But for this type of client, their proactivity is really the key element. So whilst their knowledge and digital literacy might not be strong, they're still able to look for help, talk about their experience and get what they need. So those are our archetypes. Before we move on to discuss how these archetypes really can help us to design and deliver services differently, we want to hear from you. Which of these archetypes kind of align with the clients that you see if you work in the sector, or if you aren't in the sector, which of them do you think are most reflected in your community, people who might be experiencing these kinds of problems? So we'll put the poll up now and look forward to hearing from you.
Thanks, Sahil. I'll let it run for a bit before continuing. Thank you, everyone. Yeah, it seems we've got a range of familiarities with the archetypes throughout our room. I'm seeing a fairly even split, actually. More surprised respondents than others, but Sahil and I can't vote because we're panellists on the webinar, but we've talked about that before today, and we think that we're most likely to come into contact with the accidental client here at Justice Connect, so someone referred to us. Wonderful, thanks everyone. I'm going to end that poll there and share the results. So with Sahil's description of our debtor archetypes in mind, we're going to move on now to talking about the ways to enhance and expand early intervention by kind of capturing opportunities that are available in our existing system and opportunities that are in line with the existing behaviours that we've kind of identified to be present for people with debt. So as Sahil said, our participants told us that they looked for help early. Now, there's a couple of things that relate to this finding, or perhaps they underpin it, that are really relevant to subsequent analysis that are really worth reiterating at this point. The first is that debtors are looking for help at the earliest possible moment as relevant to their circumstances. So we're going to talk about awareness in a second, but what we're saying here is not that like immediately the second something went into default that they immediately started looking for a lawyer. What we're saying is that our participants were proactive and they formed this view that that someone with expertise would be of assistance to them in resolving their problem, and they did that earlier than we anticipated. The second key point to emphasise here is that and this isn't going to be a surprise to anyone in the room, once a financial legal problem gets going, it continues to escalate and gets worse with increasing intensity as time goes on. So one of our participants from a service provider described financial legal problems as freight trains. So kind of making the analogy that they're really hard to stop once they've accelerated to top speed. And what this means for us in delivering services is the longer a person searches for help, the more time their legal problem has to escalate and the worse we can expect it to get. So what we're trying to do is catch people as early as we possibly can, because then we have an easier job in resolving their legal problem with them. So in this section, Sahil and I, we're going to share some early intervention points that we've identified. We're going to do that by taking you through this journey of navigating a financial legal problem up until the point someone finds help. We'll share what we've learnt about how services currently are delivered and arranged at this relevant point. And we'll talk about kind of what capabilities are required of debtors to engage with them at that relevant stage and put this into context with returning to these archetypes as we go. So, as we've already alluded to, we found that there's assumptions being made by service providers about the nature of debtors' awareness of their legal problem. Now, this wasn't necessarily reflected in the stories our participant told us about their experience or how they thought of things. So I think the rhetorical question on screen gets to this point. Does a debtor need to be aware that their problem has a legal element or that a legal service can help them in order for them to start looking for help? For me, there's an implied should in this question too. So should a service provider require a debtor to be aware that their problem has a legal element in order for them to start to search for that service? Or maybe wording a bit differently, at the moment, do service providers require this knowledge of potential help seekers? So we found that there's a lot of factors that influence when someone becomes aware that they have a problem. So the moment they realise that they're not going to be able to meet their debt obligations and that things are serious. And, various factors that influence how much delay there is between when they get the debt or when they first default and then when this moment of awareness kicks in. So these, factors are, broad. They can include a person's relationship to the household finances and their extent of responsibility over them or even their access to them. It can include things like financial literacy, their ability to access hardship services, to delay the onset of enforcement, how serious their financial hardship is, the kind of creditor they have, how they communicate with their creditor, all sorts of things. And we note here, and this is apparent in these journeys taken by our behavioural archetypes, how quickly this realisation occurs is important. It does have an impact on legal problem outcomes. But we found by looking at how people behave in these early stages, it's not the most important factor when we think about whether someone's able to access early intervention. So our participants became aware of their problem early enough for them to have resolved their problem early. And most of them made decisions to search for help that would have enabled us to intervene were our services appropriately targeted or appropriately responsive to the behaviour that they exhibited at that time. I'm going to hand back over to Sahil. He's going to talk about some of the insights about this journey stage, this awareness phase. But I just want to reiterate, at the risk of being repetitive here, the relevant intervention enabling paradigm here is not a debtor's association with the law, the extent to which they identify with a free legal service. So it's about decentering ourselves as legal service providers, returning to how people think and feel when they have a debt and what they do. And there are opportunities for us to ensure that help-seeking behaviour of any kind is rewarded. And it's up to us to act as that drawbridge between a person with debt and the legal system. So over to you, Sahil.
So we asked our participants to tell us about both their thinking and their actions when they realised that they had a financial legal problem. So the questions covered the places people looked for help, what kind of mediums they used, their awareness of the types of service available. And you'll see on this slide that the vast majority of participants looked for help via multiple channels. Professional expertise was clearly sought after. And amongst that group, 63% of people said that they looked for help from a lawyer. But in actual terms, that's a relatively small proportion of our participants. People were just as likely to look for help from friends and family, their creditor, other professionals like accountants. Just over half of people thought that free help would be available. I think it's really important that in the context of financial difficulties where people are unable to pay their debts, this is potentially clearly a limiting factor in people's ability to access help. In other words, if they think that they will need to pay for help, which they know that they can't afford, how likely are they to look for help from professionals? So I think that not all of our participants knew that a lawyer was the best place to go, but nevertheless, they recognised the need for expertise. They are still proactive in the face of that uncertainty, really. Next, one of the things that came out of our service provider interviews was that the idea that financial legal problems that reach a late stage without any help are often precipitated by some other major life event. So we wanted to test this finding, and we found it to be overwhelmingly true. The accidental client exemplifies this combination of major life events and proactive help seeking. The chart on the screen that you can see shows that for people who experience the life event, the light blue column is the percentage that looked for help for that issue, and then the dark blue column is the percentage of people who are then referred on for help with their legal problem. And you'll see that those looking for mental health support were most likely to be referred. And we can only speculate here, although a few of our clients did follow this exact pathway. But we think that the likelihood is that when people are looking for this kind of help, they're having conversations about the stresses in their lives, which alert professionals to the legal issue, and then the onward referral is made. And from our research, the evidence is that that's a relatively high clip. And you can see that it's happening across the board, but with varying amounts of frequency in different services. So, for example, the relatively smaller proportion of people who had a serious illness at the time of their financial problem, who received an onward referral for legal help, was comparatively lower. And so maybe there's an opportunity for more referrals from that kind of physical health space to be made. So I think the key thing here is that when experiencing a major life event, people might not have awareness of legal services or legal help available, but they are aware that the help is available and they know how to access it. And it's that key proactivity that then enables somebody to be put in touch with an appropriate service. So as help seekers become aware of their problem and they decide that they need help for it, they begin to consider their options. So if we go back to our key tenet of a strength-based approach, meeting help seekers where they are, if people haven't used free legal services before, how are they making decisions around which service to use? What information do they need? And where do they find that? So we found participants used a range of channels to find services. 70% used the internet to look for help, 61% spoke to someone over the phone, and 39% looked for help in person. But it is really important to note that almost everyone interacted with search engines at some point. So those people who prefer to look for help over the phone or in person still utilize search engines to identify services and find contact information. However, we do need to note the digital divide, that some people are able to use the internet to their advantage and others can't. So services have to compete with for-profit organisations or other providers in the space, namely debt management companies and predatory lenders, need to compete with those organisations for people's consideration to access services.
Awesome. Thanks, Sahil. So as Sahil said, all of our archetypes are interacting or they're trying to interact with services online at the beginning or the early stages of their help-seeking journey. Most of our participants and archetypes, so the dogged debtor, surprise respondent, accidental client, they all have difficulty finding appropriate services through online search, given just the extent of available information on the internet and a real lack of specificity in search results. Our dogged debtor particularly prefers to use Google. You can see that in the first quote there on screen. You know, they like to use Google for convenience, for control, for independence, and as reflected there, because they don't feel judged by the way that they talk about their legal problem. Our dogged debtor also, you know, they've realised they have a legal problem relatively early. And at this stage, they're not that flustered and they're not that prone to frustration. and this makes them relatively methodical in the way they engage with online search. However, with moderate or basic digital skills, they can find it difficult to interpret or pass through this long list of results and to discern between paid, predatory, or free services. They can also find it difficult to understand the legalese or conversations about law that's embedded in service provider websites and apply that to their situation. Nonetheless, it's the preferred help-seeking channel. Importantly for us as service providers, I think what we need to remember is that a debtor using the internet to find services have begun a search for help, meaning that they've completed that first step of realising it's time to seek out an expert on their own, and in doing so made our jobs easier. So on screen, several examples of the kind of language participants and real help seekers used when searching for help and searching for financial legal problems. So what stands out here is how generic the language is. So these people are looking for help with a debt problem. There's really no mention of debt in these search terms or financial stress. So it's lacking area of law specificity. And there's not much in there around who the person searching for help is or what stage their problem is at. And that's to say the kinds of language that we use when we name our services, our organisations, and design our websites, and that guide us when we set our eligibility criteria. But again, we can reframe this. We have extra knowledge here. So reframe this through strength-based language and think about what tools are at our disposal already to meet clients where they are in the language they're currently using and through the kind of tools on the internet that are available to them. And so here we have an opportunity. So we understand how our potential clients use online search engines. We can take that next step, ensuring we maintain consistent and strong presences in the digital spaces that they frequent, leveraging their natural language, and responding to this existing behavioural characteristic, which is an inclination to go online. And by doing that, expanding access. So we'll return to this later when we start talking about putting things into practice. But there are tools at our disposal to ensure that the right people, based on risk indicators and our understanding of our service cohorts, are presented with pathways into our services when using a search, regardless of how generic the language used is. And again, the better we do this, the faster someone can identify who to ask for help, the less their problem's accelerated. So once an individual identifies a service, makes an application for assistance, another opportunity for early intervention presents, and that's in how we assess eligibility for our services. So we heard repeatedly from our participants that if they did end up getting a service, the person that they got it for at the later stages of their problem was actually someone that they'd asked for help much earlier on and not been able to access. So they've been told they're ineligible. So there's a lot of factors why someone might be ineligible for service, despite having an actionable legal problem. You know, firstly, to get the obvious point out of the way, services may deal with a priority cohort or an area of law. It's not relevant for financial legal problems. You know, we know that debtors cast wide nets when making applications, and we know that a debtor, that means they're going to be ineligible for a lot of the services that they apply to. But, and it's an important but, debtors are being turned away from services that do have the expertise to help them. And part of what we've uncovered here is that's partly because some of the ways that we think about eligibility in our sector. So our guidelines, they're often tied to things like what stage a legal matter is at. So some services will require legal proceedings to be on foot or threatened, or some kind of document to come through the post. Services often prioritise later stage matters for their most intensive services. We also make assessments on vulnerability that are based on kind of demographic assumptions about certain groups in the exact moment in which they're applying. So we're asking questions like, what's this person's means now? Excuse me. Do they have non-financial vulnerabilities at the moment? Do they have time before things get really serious? So really point in time focused in how we think about assessing a person's circumstances. What we've kind of putting forward through this research is that if we want to be able to do early intervention, we kind of need to reframe the way we think about legal need when it comes to this application process. So in order to capture people who are at risk of financial legal problem escalating towards bankruptcy, we need to deal with them where they might be at that point of risk, right? Rather than wait for things to get really bad before deciding to jump in and help, waiting for, you know, their material circumstances to already be impacted or their home to already be at risk, or for them to be, them and their families to be experiencing this kind of financial hardship that then brings them to our attention when we assess eligibility. So our repeat player is particularly benefited by an intervention of this sort. So a repeat player's legal problem, as a reminder, it's kind of likely to have some kind of commercial origin, even if now that they're searching for help, it's a personal legal problem and they're liable personally for a series of debts. This person is likely to own a family home. They can often be deprioritised, therefore, on means tests. They also might have a slightly higher income than other applicants. Perhaps they used to own a business. So these factors lead services, we've found, to assume that potential consequences of not receiving a service might not be as significant as other people, and that wherever this person finds themselves, it'll be materially recoverable from. These factors also lead people to make assumptions about, based on this demographic cohort. And for this repeat player, it's often an overvaluation of their legal capability. So as one of our service providers participants explains in this quote on screen now, repeat players are very unlikely to be able to access a service early, but they also can't afford paid services. Despite that, they experience the same consequences of bankruptcy as any other individual, regardless of its commercial origins, and whatever their professional standing may have been in a former life.
There's also a range of other factors that I think that we should be considering when it comes to assessing eligibility, and I think they can help to prevent people like our repeat player from falling through the cracks. So a client's legal capability, their motivation and resilience, the enforcement avenues available to a creditor, and the likelihood of getting help elsewhere, I think are chief amongst them. Each of these considerations really prompts some further questions or thinking for a service. So is the person in front of you likely to carry on looking for help if your service is unable to help? Are they capable of taking some action, like responding to a letter of demand without any substantial guidance? What are the likely actions of the creditor if the situation doesn't change for the client? And to answer these, it's likely that you need more information, potentially from the person in front of you. But really thinking about how to help that client to formulate the plan of what to do next if they're not receiving a service, or tailoring a service to meet their needs, creates the problem for creates the potential for problem resolution. And I think the key point here is that the eligibility criteria isn't fixed to what's happening right now, as Mel said. It's really about thinking about what might happen in the future. Intervening early relies on this kind of assessment of the potential impact of the service, and considering all the factors at play, rather than what's happening just now. So no matter the extent to which we try and reframe legal need to encompass a broader base of people in order to intervene early and resolve problems, there's always going to be some applicants for services which we can't help. And we'll always need to make referrals to other services for that. I think it's important again to remember that the longer that someone's looking for help, and the longer it takes them to connect to the right service, the worse their problem is going to get. So to help debtors, to find help, debtors must be resilient. They have to hold certain capabilities. They must find services on their own, sometimes with incomplete, unclear, or really complicated information at their disposal. And they're forced to cast a wide net when applying for services, even if they don't want to. Then, when they're declined by a service, they must probably look for another, and they need to be able to follow information on their own. So cold referral instructions like emails or phone numbers. And so we found that in this process of making referrals, given the reliance on the proactive outreach on the part of the help seeker, following through on a referral that was provided to them off the back of an application with information about their matter and without the context of that person's help seeking history, that referral roundabouts continue to affect help seeking. They can discourage and interfere with the timely provision of legal help. The referral roundabout will be a familiar concept to service providers in the room, but for everyone else, it's what happens when someone's referred from one place to another, and then to another, and so on and so forth, which can and often does leave a debtor back where they started. So sometimes that can lead to a service because the matter has progressed, and now that they've gotten back around to the first person they contacted, they're eligible for help, but their legal problem has gotten substantially worse. And I think when a debtor enters a referral roundabout, It's important to remember that time doesn't stop. The legal problem continues to get worse. The size of the underlying debt can grow, and they can start to face threats of court or miss key dates. We found several reasons that referral roundabouts were particularly pervasive in the context of financial legal problems. So some of the reason was that there are many reasons that these kinds of problems start. They're relevant for different groups of people. And because of this, there's lots of services out there that do this kind of work. We also found that waiting times and capacity impacts the services that an organisation offers. So our sector scales up and down their services often according to what they can achieve at any given time, sometimes with implications for who is and who isn't eligible for our services. These changes in criteria, along with funding sources, mean that we might have to pivot in certain directions to respond to other priorities. But we also found that we're not necessarily that great at keeping each other up to date and in the loop about these things. Sometimes we don't actively share wait times. Changes to eligibility guidelines can often get lost in busy inboxes, and we maybe don't provide regular feedback to one another on the quality of referrals that we're making. So as one of our participants said, you contact one person, they say go to this person, then another person says go to another person. You don't ever get a service, you get overwhelmed, and it's like a revolving door.
Thanks for sharing that quote, Sahil. I think it's really perfect and really encapsulates the experience of many of our participants. And I really want to narrow in on that second to last part of the quote, which speaks to the impact that referral roundabouts have on debtors looking for help. So you get overwhelmed. What this speaks to for me is that the referral process that we have at present imagines that just someone can just keep going for as long as it takes in order to be connected with the right person. And, maybe because of that, we view off-ramping or sending referral information to ineligible clients as more of an administrative task that we perform in a service, as opposed to like a crucial moment of intervention that's really crucial to this person's problem resolution. So for some, For some, like our dog or debtor, this ability to persist might be there for them. For others, like our surprise respondent, being declined repeated services leads to a feeling of helplessness, of overwhelm, and a sense that no one can or that no one is willing to help them. And this can cause them to disengage and stop help seeking. It's a really alienating feeling, and they think, well, nobody's out there for me, so I'm just going to stop. And that's what what our participants reported again and again to us. Again, I'm being repetitive. When they stop looking for help, the creditor doesn't stop coming after them. Sahil's already mentioned this data earlier in our presentation, but I want to return to it because it's really relevant here. So we asked our participants whether they look for help at various stages of their problem. So again, almost all of them said they looked for help when they first realised they had a problem. That figure drops from 96% to 86% when legal action is first threatened. And then it drops again to a shocking 46% at the final stages. And this might be why we're hearing reports from service providers that people are kind of sticking in their head in the sand and avoiding their legal problem. Because between this point of legal action threatened and the final stage, it seems like that does happen. So perhaps, this reflection's right, but maybe with like a wrong diagnosis as to the emotional state going on here for the debtor. So our surprise respondent, who had a really serious legal problem, seemingly thrust upon them, they're really susceptible to disengagement. They're already stressed, and looking for help just makes it worse. They're really bewildered by the navigation process. They're also, therefore, if they do drop off, really at substantial risk of being lost to the system if us as service providers aren't jumping on that opportunity presented when they first present to a service. So we can do this by providing support to navigators when they come to us, even when they can't help. So perhaps that looks like more actively sharing information with one another in the sector about how our wait times are, how our eligibility is shifted. Perhaps it's about building horizontal relationships throughout the sector so you can get on the phone, double check that there's a referral someone can take before you send it. All sorts of things like that. So before we kind of move on and talk about putting this into practice, we're going to pause for another temperature check. So we'd like to know, with the archetype in mind that you kind of identified in that last poll or in the context of your work or in your community, what intervention point do you think you'd be most likely to explore, or that you think would most benefit the community that you belong to. Oh, sorry, let me get it going. There we go. Fantastic, everyone. It's really great to see those responses coming in. Seeing awareness and referrals as the two key main things that are relevant to people in the room today is wonderful. While that's going, let's move on. So it's all very well for us to identify the range of opportunities in front of us or tell you what crucial moments are in a person's journey to bankruptcy in which we could be intervening. But then the question arises, how do you actually do it? We don't have all the answers, and how it's done is going to be different depending on your context, the clientele of a service, what your strategy is, all that kind of stuff. But we have a few ideas and recommendations. Most of them live in our report, but we'll touch on a couple today. So after we developed our archetypes and we developed some insights into early intervention and some of these opportunities that we've talked about today, we've set about piloting a service to put some ideas into practice. So we kind of viewed our research with participants as a co-design process where we learned about what was important to them and how they behaved, and then had the intention that we'll adapt a service that we've got around those, expressed needs and wants of potential clients, and as opposed to any kind of pre-existing thoughts we had about the service. I'll just end this poll and share the results. Cool. So we adapted an existing service here at Justice Connect called Justice Connect Answers, or JCA. If you're not familiar with it, JCA is an online legal clinic where people ask questions of our volunteer lawyers. Volunteer lawyers then use the online platform to communicate with help seekers, so provide answers to questions. So they provide written advice or information, whatever is required really based on the question asked and the problem being experienced by the question asker. A quick acknowledgement here of the team at Wotton & Carney who provided invaluable support to us as our volunteer lawyers for this pilot service. I know a couple of you are here today, so a shout out to you and a big thanks. JCA is an existing service, and I think what's important here, and maybe has been foreshadowed through those interventions we've already talked about, is that we didn't change that much about how the service operates once a person asks a question and starts receiving a service. So we wanted to test our assertion that we made right at the start of this presentation, which is the wheel doesn't need reinventing. What we did do is make a substantial changes to the pathways into the service, focused on making the most of those 4 intervention points we've gone over today, in the hope that this would catch people early in their search for help and give them, the right nudge that they needed to get off that path of escalation. So what did this look like, Sahil?
So it looked different at each intervention point. So at the first point of awareness, as we've talked about, people become aware of their problem relatively early and they start searching for help. So our research participants started looking often before there was any enforcement action being planned or enacted by their creditors. So what we did was we didn't limit the use of this service based on what stage a legal problem was up to. So provided the question was capable of being answered online in a discrete format, we allowed that question to come through the platform and to be answered, to be posted on the platform for answering. In the consideration stage, again, as we've discussed, debtors search for help online and they come up against this kind of crowded, confusing digital space. And in terms of the strategy that we used to intervene here and to ensure that we made obvious the pathway into free legal help, is that we knew quite a lot about the profile of the people at risk. So we knew geographically where they tended to be in Victoria. We knew that what kind of professions we might expect them to have. We knew about the likely demographics, so the ages, the genders. And we also knew what kind of search terms they were likely to use. So through all of that, we used paid digital outreach, so sponsoring posts on Google to ensure that people who fit that risk profile and were engaged in the search for help were shown our service in the first page of results. And this drove a substantial amount of traffic through to JCA, where beforehand help seekers had found the service organically. They tended to ask questions that were related to the enforcement of debt collection. So that was in the courts, where they were dealing with very kind of active and stressful legal problems. We started seeing questions that tended to be earlier in the process. So we had questions around loan contracts, about debt collection agencies, about options with your bank if you were in financial hardship, or about the lawfulness of fees charged, of fees and charges issued by service providers. And so these questions, which regarded earlier stages of financial legal problem, covered a diverse range of topics, which kind of leads us to that next intervention point, the application of eligibility criteria. So we didn't institute an asset test, which is typical for our other services, and we didn't have any pre-existing area of law restrictions in place. So, except where they were absolutely necessary given our volunteer lawyers' expertise. So when making eligibility assessments, we asked the question, does the person in front of us have a foreseeable risk that their problem will become a financial legal problem if it isn't one already? And does the problem have a chance of escalating to bankruptcy if this person doesn't receive any help, no matter how far in the future that bankruptcy might come? And there were, of course, people that we couldn't help. So as an online legal clinic, some matters were too complicated for discrete written advice. We were lucky to have worked with a range of service providers through this research, and some had some partnerships set up ahead of time. And we were also lucky to have a range of colleagues within Justice Connect working in other services that help with financial legal problems. And so through all of that, we made referrals only to places where we knew they would be able to help. And we really knew this by checking first. So the success rate of our referrals was really high and hopefully ended people's help-seeking journey once they've made that referral.
Thanks, Sahil. So yeah, like Sahil said, the pilot was on the whole successful. Like Sahil said, we were able to attract clients in early stages of legal problems, which demonstrates that these people are out there looking for help. And we're able to provide services to them at that point in which they were searching that they might not have been able to receive elsewhere because things hadn't started to really become legal yet in the traditional sense. So we shorten the time spent help seeking for these debtors, and also we think for debtors that we referred on. I'm just going to quickly talk about a success story and a happy note to finish us off. So this client, when we learned about her circumstances through an evaluation process, we kind of figured that this person was more closely aligned with our surprise respondent archetype. So Esha's not the client's real name. We've changed to protect her privacy. But Esha and her family were experiencing immense financial stress. Esha was unemployed. She had left her old job due to sexual harassment. And this had caused experiences of depression. And there were some other health concerns going on that were making it harder for her to find a new job. Esha's husband had recently liquidated a business, and the combination of these two things meant that they had no income as a family. So suddenly, out of the blue, Esha received a final notice that she owed more than $18,000 in unpaid driving fines. The fines had been left unpaid for so long that her property was now kind of in a risk zone of being able to be seized to pay off a debt. Like our surprise respondent, this meant that Esha's legal problem was substantially underway by the time that she became aware of it. But once she became aware, she immediately started looking for help. Amongst everything else going on, Esha was experiencing family violence perpetrated by her husband. And it was within this context that the fines had been acquired. He was the one that had acquired them, driving Esha's car in the course of running his business and accruing the fines in her name. So she didn't feel safe and comfortable to go through a process of having the fines transferred over to her husband and nominating a different driver. Esha spent about 4 to 5 weeks looking for help after receiving this notice in the mail. She was willing to pay in instalments. She needed someone to help her negotiate them or give her some guidance, as her mental ill health and unfamiliarity with how to go about something like that left her feeling really worried about doing it her own. And she also knew that any instalments, given the circumstances, were going to put her family in even greater hardship. Esha found JCA through one of our Google advertisements. So she made an account and she asked our lawyers what steps she could take to arrange an extension to pay or to get a payment plan. So the volunteer lawyer provided Esha with a template letter that laid out her circumstances and some advice, which really went down to what steps she could take to provide this letter to the creditor and start a negotiation process to hopefully negotiate a payment plan that would be successful. So using the advice, Esha kind of told us afterwards that she felt, armed with this advice, really empowered to negotiate on her own. And she went out there and she kind of upped the ante and didn't just go for a payment plan. She negotiated on her own. She got all of her fines waived. So $18,000 in fines completely waived. At the first, with the first place she was able to access the service from, which is a really wonderful outcome. And it's not unique to Esha's story. A range of participants throughout this story all kind of reported this sense of being empowered because they were able to access a service and gaining skills with which to resolve their legal problems on their own.
So Esha's experience and the experience of all of our pilot clients really can be linked back to the principles that we talked about at the start. So putting people at the centre of services, reframing financial legal needs, prioritising early intervention, particularly through supporting legal system navigation, and working with people at all capability levels. So just to wrap up, I think the things that changed the most for us, particularly in our pilot service delivery, were really about where we focused our attention. And by directing this at the front door rather than what was going on within the service, we were able to reach people that we typically hadn't reached at a much earlier stage. So that's it from us as presenters. Thank you all for listening. We hope you found today's session useful. We'd love for you to read the full report on how people navigate financial legal problems. It's available on the Fair Matters blog on the Justice Connect website. And we've got some time for some questions now. So I don't know if anything's come through the Q&A now, but if anyone has any questions, please feel free to ask them now.
No questions yet, but we'll let it run for a little bit to see if anyone's got any burning questions they'd like to ask. No pressure. Doesn't look like anything's coming through, so perhaps we'll wrap and just what we'll do is we'll pop our contact information in the chat of today's webinar so you know where to reach us if anything comes to mind later on. And yeah, please consider this as a big encouragement to go to our website and read the full report. And thank you all for spending an hour and 10 minutes with us today. Bye.
So